right. I think we're live, but if someone could tell me that we are and confirm that, that'd be really nice. So I'm waiting for someone to confirm in the chat that you actually can see me, you can hear me, and then we go from there. All right, wonderful. So welcome to my second live. I'm Andrei Mincov, the founder of Trademark Factory. Really excited to have you on here. What we're going to do is, in the beginning, I'm going to quickly go through. In the beginning, I'm going to quickly go through the topic that I hear people ask me all the time, and once we're done with that, I'll be more than happy to answer everyone's questions. So the topic that I wanted to cover today is when you use the TM symbol, when you use the R in a circle symbol, what do each of those mean, and what happens if you use the wrong one. So let's start with the important thing. You're not required to use any of those symbols. You're not required to put a TM. You're not required to put an R in a circle. All of that, if you use it correctly, could add a little bit of a bonus to how your brand is perceived, but none of that is required in order for you to have a brand, have a trademark, and it's just an icing on the cake. So let me start with just a general definition, and we'll go into specific details in a moment. So TM could mean a lot of different things. It could mean a pending trademark, a trademark that was filed with the trademarks office. It could mean a trademark that was registered. It could mean a trademark that was never filed. It could mean a trademark that was at some point filed but got denied. It could mean a trademark that was filed, registered, and never renewed. So it could mean pretty much anything, just like a brand with no symbols next to it could mean pretty much anything. R in a circle, on the other hand, means that it's a registered trademark. And different countries treat this differently in terms of what's going to happen if you use an R in a circle next to a brand that is not registered as a trademark in that country. So for example, US is a lot meaner to brand owners who do that. It could disqualify your trademark from ever being registered with the USPTO if they find out that you used the R in a circle symbol before your trademark got registered. So you have to be very careful there. Some countries are not as strict about it, but the good rule of thumb is if you don't have a registered trademark, don't use the R in a circle next to it. The funky question really around that is trademarks are registered on a per country basis. So what happens if you have a trademark registered in one country but you don't have it registered in the other country? Can you still use the R in a circle? And the answer to that is it depends, right? Again, going back to different countries being having different standards in terms of what's okay and what's not okay, and when it's okay to use an R in a circle without a registered trademark. So for example, if you are a Canadian brand, you've got a registration of your trademark in Canada, but you're selling a lot of your products in the US and those products carry the R in a circle mark, and you don't have a US registration, that would be a big no-no. Because again, if at any time you do decide to register that trademark in the US, your own products that are marked with the R in a circle from your Canadian registration could harm your ability to get that registration in the US. And that brings me back to why sometimes brands with registered trademarks use the TM symbol, precisely because of that. Because they don't want to run into issues with, we don't know where this brand is going to be seen. We don't know where this brand is going to be sold. And that may be one of those countries where we don't have a registered trademark yet. So why don't we play it safe and put the TM symbol next to our brand rather than our inner circle. So again, most countries are not as strict about the improper use of the R in a circle symbol, because in the US it's basically deemed to be fraud on the USPTO and fraud on the consumers that you're claiming that you have a registered trademark when you don't, right? Most countries didn't go that far. So going back to TM, like I said, could mean pretty much anything, right? It could be a registered trademark. So if you looked at it, I believe Google has been using TM next to their brand for years. And that's one of the reasons, because they may not have it trademarked everywhere, or I don't know, maybe they don't like the R in a circle symbol. Google can do pretty much anything with how big they are. They recently survived a big case in Supreme Court of the US when someone tried to argue that the name Google was generic and should no longer be protected as a trademark, so they were able to withstand that onslaught. Having said that, so going back to TM, right, it could be a registered trademark, it could be registered somewhere else, could be registered in that same country. It could also mean that you've got a pending trademark before the Trademarks Office in either stage of it, right? It could be you just file your trademark, you put a TM next to it. It could be your trademark got approved by the trademarks examiner. It could be that it got rejected by the trademark examiner. It could be that it's allowed. It could be that it's pending opposition. It could be really any stage. So you could put that TM next to it. And then the last possibility with TM is that it could be a trademark that you never even filed for, just a trademark that or just a brand that you want the world to think it is your trademark. So the only way to really do something about it is to really know, whether someone else's trademark is applied for, registered, is to check the Trademarks Office database, do a proper trademark search, and that's how you will know whether or not that TM, what it means, right? And that's why you can never really rely on that TM, on the R in the circle, or lack thereof, because that's how you make those decisions. So that's the quick introduction to the distinction between TM and R in a circle. And so one thing we often get asked is at which point do I want to start putting that TM or R in a circle next to my brand, and at which point is it safe to put my products or services out on the market while we're going with the trademarking process. So TM you can put right away, right? You don't need anyone's permission to put a TM next to your brand. Whatever you feel like, put a TM next to it. It's not going to hurt at any point. R in a circle, don't put it there unless you've got it registered as a trademark in the main jurisdictions where you're trying to sell your products and services. That's the good rule of thumb. And as for putting your products or services out there on the market, or similar question that often arises, if you see that someone is copying you, do you want to wait till your trademark gets registered, or do you go after them as soon as you file your trademark, or as soon as it's approved, or as soon as it's allowed? So there could be different situations, and really the answer is you need to know what your competitors are and what they do, and why they might have a similar product or service to yours in terms of the brand. Because if you copied from them, or they can reasonably make that case, you don't necessarily want to attract their attention so that they don't oppose your trademark. And in that case, you want to make sure that your trademark application gets approved, survives the opposition period, gets allowed. At that point, it's pretty safe to do whatever you want. It's pretty safe to start sending demand letters. It's pretty safe to have your products and services out there, and then your trademark will go straight through registration. However, this is really the probably the most fearful scenario, right? The most paranoid scenario when you wait all the way till the end before you start using your products, before you put your services on the market, and before you start telling others not to steal from you. If you know that you've got a good case, that you were there first, that they came after you, that there's no way they can prove that you copied from them, then it's probably a good idea for you to start taking advantage of that brand that you're building sooner rather than later. Because the trademarking process is a long process, can easily take more than a year, and usually does. In some countries like Canada, it's now more like 3 or 4 years before your trademark gets registered. So, it's if you wait until it registers, you're going to lose that momentum. You're probably not going to be as excited about that brand in 3, 4 years. And we get those emails from clients all the time, like, "Hey, you filed our trademark in 2019. Why isn't it registered yet?" Like, well, that's the Canadian government. That's how they operate. That's the Canadian Trademarks Office. And they're like, we were a lot more excited about this brand in 2019 than we are today. And unfortunately, there's very little we can do about that, because Canadians, they say, well, we got a backlog, and your trademark will be examined sometime soon. So that's the best you can get from them. So that's the mandatory segment of this live where I wanted to kind of give you a little bit of an introduction to a topic that I get asked all the time. And I'll be more than happy to switch to questions. There's quite a bit of questions we got, and we're going to go with those. So, like I said, I'm pretty new to doing these lives, and if it's a little awkward, then it's only because I have no idea what the hell I'm doing. So I'll be going through these questions, and thank you for sticking around. So I know that there was a question before the whole thing started from Quantum Hosting, and the question was whether I've ever had a crazy and zealous trademark examiner during one of our registration. Well, yeah, unfortunately, it was more than one. And really, that's how the whole idea of Trademark Factory was born in the beginning, because, you realize that it's not just about you doing something wrong and having to pay the price for it in terms of, giving the money back guarantee, and which is, we're the only firm that does that, or, having an ability to predict really what's going to happen. Or find an excuse why things didn't go the way they should have gone, and that's really what most law firms do, right? It's very easy to write off your failure to help achieve the result that you promised you would achieve by saying, "Oh, we got an idiot examiner," right? They didn't understand the law, they didn't understand the situation, but we did everything we could. Here's the final bill, but there will be no money back for you, even if they told you that it should go through. Like I said, it's very easy to write it off by saying that the problem was with the examiner, and often it is. Often it really is, and I'll give the example that comes to mind right away in a moment. But what I wanted to do with Trademark Factory is basically to remove all these excuses from this conversation that we have with our clients, and say, look, if we told you it's going to go through and it doesn't, then it's our problem, not yours, right? And that's why we got all these clients who come to us and want to use our services as opposed to using traditional law firms. Because look, when it comes to the actual trademarking, the actual legal service, there's very little we can do differently when it comes to dealing with the Trademarks Office, right? For example, when we file trademarks in the U.S., we actually use licensed U.S. attorneys who do all the work with the Trademarks Office. The reason people go to us is because of the way we package the service, right? The one flat fee, the money back guarantee, which lawyers are not going to offer you. So that's kind of the general answer. And the specific example that I still remember, we had a client who came to us after they filed their trademark, so we didn't file it for them. And it was rejected by the Canadian Trademarks Office. The name was Meat Restaurant, meat as in meat restaurant, and or meat cafe, something like that. Meat, I think it was meat restaurant, but something around that idea. And the Canadian Trademarks Office thought that the mark was descriptive of steakhouses. And I'm like, what does this have to do with steakhouses? So we write back and saying that this is nothing to do with meat that you eat. It's everything to do with a place that people can go and meet each other and have a conversation. And because of the way it was worded, it wasn't descriptive of the service. And the trademark examiners said, no, I still think it's descriptive of meat restaurants, steakhouses. And so we go back to the client. And of course, you know, we promised that we looked at the office action initially. We gave the client a flat fee, said it should be relatively easy to deal with this objection. So we're going to charge you one flat fee, and we're going to take it all the way to the final result. I wish we didn't make that offer, but really what happened was, so we responded, and they said no again. So we went back to the client, and turned out that they don't even serve meat in their restaurant. They are they're a vegetarian, vegan restaurant, right? And so like, okay, this should be enough to convince the Trademarks Office that it's not descriptive. So we provide all this information. We write a long response full of great arguments. And then several months later, we hear back from the Trademarks Office. Well, they say if you're a vegan restaurant, then your trademark is not merely descriptive. It's deceptively misdescriptive, because people who see that will think they're actually going to a steakhouse when they're not. And it was just a complete clusterfuck. It was a complete disaster. There was really no way to convince this examiner that his idea that the restaurant had anything to do with meat, and that the public would think about this as a meat restaurant, as a steakhouse, had nothing to do with that. So eventually that trademark did not go through, and that unfortunately was the end of it. So that one I will always remember with a lot of disdain. We had something similar. We had something similar with. Okay, so I'm getting some help with the questions here, so that's good. We had some disdain with European Trademarks Office as well. There was a trademark that had a logo, a very inventive way to show a logo that was basically a tire transformed to look like a recycling symbol. And they thought that was descriptive of something, and that made zero sense. And again, we fought it, and that did not go through. So really, when the Trademarks Office gets back to you with one of those substantive office actions like confusing similarity or descriptiveness, it's very difficult to overcome those. And in most cases, we're successful at those, but of course there are a few of those when we're not, and it's annoying. But really, that's what allows us to be the only company that offers the money back guarantee, and that's the only, and also be the company that has a 99.3% rate of success, because we fight harder. All right, so I think that answers that question. So, okay. So that's a great question from Austral Economics. What's the average lawyer fee to file trademark from A to Z compared to your price? you don't know, right? That's the thing with traditional law firms. You never know. You have no idea what it's going to be, because it's one thing to just file your trademark, and that part is relatively easy, right? Anyone can file a trademark. A monkey can file a trademark. It's what happens after that matters. So lawyers typically would charge you, I don't know, about $500 to maybe $1,700. That's kind of about the range what they charge to file your trademark. And some of them will include the simple office actions into it. Most of them won't. But really the real cost starts when your trademark gets that office action about descriptiveness, genericness, or confusing similarity, which brings me to something I remembered just now. Elon Musk, right? He's got his Boring Company, and he filed his trademark for that, and it was originally refused because they said it was either generic or descriptive, or one of those two things. And his lawyers filed a response to that office action that I think was either 60 pages or like 100 and something pages. And whether it was 60 or 100 something, the important thing, it took a lot of lawyer hours to write that. So if you multiply those hours by, I don't know, 300, 500, which is pretty much what an average trademark attorney would charge you by the hour, you're going to see that your $500 filing or $1,700 filing can easily become a five-figure proposition. So, and that's really the problem with dealing with traditional law firms. And so, to Elon Musk's honor, their lawyers did the right thing. They responded and they won, right? So it went through. And basically they argued that boring has two meanings in English, and that's really what was the genius behind the name. And they were able to convince the Trademarks Office that the trademark should have gone through. But again, I can only imagine what it costs to get that through, right? And you never know what's it going to be until the process is over. With Trademark Factory, it's one flat fee that covers everything from start to finish. So if we get one of those nightmare scenarios, then it's our problem. Funny enough, I just recorded a short testimonial from one of our clients. We spent 4 years fighting for his trademark, and there was a lot of back and forth, a lot of negotiation with third parties, and a lot of arguments between us and the Trademarks Office. And one of the first things he said is that, you guys probably didn't make any money on us. I'm like, no, we lost a lot of money on you. But that's really, all those case studies are the best examples why sometimes it's, going with Trademark Factory is the most reasonable thing you can do for your business. Sometimes if it's really straightforward, you can probably get it done cheaper elsewhere, but you will never know. So in terms of us, on average, a client would spend about $3,200 plus the government fees with us. And that the reason I say on average is because some people go with one trademark, some go with name and a logo, and we have some bundles around that, name, logo, tagline, and sometimes you go with one country, and sometimes you go with multiple countries. So if, with all of those variables, the average client would spend about $3,200 with us, and they would know exactly what the number will be before they get started. So that's really the benefit of doing it with Trademark Factory. All right, so here's another question. Habits to happiness. Should my YouTube channel be trademarked? It depends what you do with your YouTube channel, and whether that has a business component to it, right? Whether you're planning to monetize it, whether you're planning to grow it, whether you're planning to turn that channel into a front end for your business on the back end. That's important. I mean, some of the biggest Some of the biggest YouTubers, of course, have all trademarked their businesses. You know, the PewDiePies, and we did a trademark for one of them, improvement pill, right? So that's why you know, if you create a brand and your brand is you on YouTube, yes, by all means, you do need to trademark that. If it's just something that only your mom and your cat watches, you know, once in a while, probably not. So again, boils down to, is there a monetization strategy? Is there a way for you to, you know, build this into something that can live outside of YouTube as well? So I hope that answers that question. What else we got? Generic. All right, so that's a great question. Can I trademark a generic name if there are no similar active trademarks, and what's considered a generic mark? So generic mark is when you try to trademark the name of the dictionary name of the actual thing. So you cannot trademark phone if you're selling phones. You can't trademark the word apple if you're selling apples. You can't trademark the word pencil if you're selling pencils, because, and the reasoning behind that is that trademarks are designed to do a couple of things. One of those things is they're designed to help the marketplace tell your products and services apart from identical or similar products and services of everyone else. If you were to be allowed to trademark the generic name for the product, like if you're selling apples and you could trademark the word apple, then nobody else could be allowed to call their apples apples, right? Which would be, of course, patently unfair. So the trademark laws of pretty much every country will not allow you to do that. There's a reason why there are no active marks, because nobody's even trying. Those who have tried, they're all failed. So there's a whole spectrum of what's called spectrum of distinctiveness in terms of how distinctive your mark is. And generic is really at the very bottom of that. It's the worst you can think of. And, you know, if you think, what brand should I never go for? You know, what brand sucks the most? It would be the generic brand, because it's not a brand really. It's you just trying to usurp and monopolize the name that everyone uses to refer to that particular product or service. A step up from that would be descriptive brands, which are also looked at poorly by the Trademarks Office. You can do a few things with them in the US. You can register them on the supplemental register, but in most countries you can't register descriptive trademarks. Descriptive trademark is the one that doesn't refer to the product or service by its proper name, but that describes a feature or a characteristic of that product or service in a way that, again, will prevent your competitors from selling their products and services with the same feature, and calling that feature again by its name. So, for example, if you sell printers, you couldn't trademark color printer, because if you did, then that would mean that nobody else could sell color printers, and that's not the function of a trademark. So, going to go back to your question, no, you can't trademark a generic name, not even on the supplemental register. And I just got a note from someone that the sound of that bell is too loud. I'm sorry. I'm gonna fix that for the next live. I'm gonna fix that for the next live. I can't fix it now. Good news, it only goes out, I think, like every 10 minutes. So bear with me. What else we got? Let's see. African Flight Star asks, if we launch our business with our brand name right after we have filed the application for our trademark and we get challenged right at the start, how do we defend and what could the cost be? So if you know that your brand can be attacked, then you probably know by whom and you probably know why. And that should really lead to your question, is it worth trying to do that? Because if you know that someone's got a good chance at preventing you from using that brand, really everything you do trying to build that could just be a cost, an expense, and a waste that will never grow into something that becomes an investment, something that builds an asset for you. So that's really where I would start that conversation. You know, if just because you ran to the trademarks office first doesn't necessarily mean you're going to get that trademark. It's oftentimes, in most cases, it's the right thing to do. But if you're knowingly trying to trademark someone else's brand, it can cost you a lot, right? If it goes to opposition proceedings, so for example, they choose to wait until your trademark goes to the trademarks office, and let's say it goes through the approval status, and then it opens the opposition period, so they can oppose your mark, and that can easily cost you $30,000-$50,000 if it goes all the way. And you can easily lose as well if they can prove that they were using that brand before you, and or there's some other reason why you shouldn't have that registration. So again, don't knowingly copy somebody else's brands and run through the trademarks office, so much so that when we get clients, and you know, once in a while we do, who come to us and they say, well, you know, there's this other firm, but we like their brand so much it doesn't look like they trademarked it. Can we trademark their brand? I'm like, no. I mean, maybe someone else is going to do that for you. We won't, because you know, the reason I started Trademark Factory was to help entrepreneurs build amazing brands, not steal amazing brands from someone else. So if we find out that you've taken your brand from someone who's actively using it, just didn't bother to trademark it, we will not work with you. We won't go to the other guys. We will not tell them because that'd be conflict of interest, but we will just refuse to act for you. It's not really a matter of money. Also, you know, since I mentioned opposition proceedings, we do have a package that's called an ultimate package that covers opposition proceedings, but it covers what we call unexpected oppositions. Right? Oppositions are what we call an atomic bomb that almost never goes off, right? They happen in less than 1% of the cases, and obviously it's very rare occurrence. And but when they do happen, they tend to be super expensive. So we have a package that covers them, almost like an insurance against those, but we only cover unexpected opposition. So if it turns out, whether you tell us or with their evidence, we see that you knew or should have known that it's their brand. Like, for example, they say, well, we sent your client a letter, you know, 2 weeks before they file their trademark, stating that it's our brand, and they nevertheless came to us, didn't tell us about it, and we filed their trademark, and of course it got opposed. It will not be covered by the ultimate package, right? So that's the deal with oppositions. And let's go see what the next question was. All right. John Smith. I already applied trademark in Canada. It seems that either have to hire a lawyer to do it in the US, or I can apply through Madrid Protocol. The cost all starts around $1,000. Any thoughts? So if you're only doing one jurisdiction, forget Madrid Protocol. Really, really, really bad idea. Because Madrid Protocol trademarks are dependent on your trademark in your home country. That's the first problem. So if something happens with your Canadian trademark, let's say it doesn't go through, doesn't get registered, or it gets canceled for whatever reason, gets opposed, then your trademarks in all the other countries that you file through Madrid Protocol will also die automatically. Even if they could have gone through directly, they will be rejected. The second reason not to do it is the cost, because if you're only doing one country, it's cheaper to do it directly in the US. We typically say that it starts making sense to do Madrid when you're doing at least 5 trademarks, not 5 trademarks, 5 countries. Probably really you start seeing the benefits starting from 7 or 8. So if you're only looking at US, forget Madrid Protocol, not a good idea at all. In terms of US, yes. So US now requires that if you're not resident or your company is not resident in the US, you must have an attorney of record who's a US licensed attorney. If you are resident in the US, you are allowed to file your own trademark, but not if you're not a resident. So if you're based in Canada, you have to find a US licensed attorney who's going to do that for you. And so we're a Canadian company, right? We can't directly file in the US. So what we do, of course, is that we have arrangements with a number of US firms who help our clients file their trademarks. So we represent our clients before the attorneys, and the attorneys represent our clients before the USPTO. That's how it works. And really, clients hire us so they don't have to deal directly with lawyers and their fees and their miscommunications and all of that stuff. So that I hope answers your question. So, and again, in terms of price, going through us will cost you more than $1,000, but you're going to get one flat fee that covers the whole process from start to finish, no matter what, and you're going to get 100% money back guarantee in case you don't get the result that you're paying for. Okay. What else we got? Diana Goss. Once you have a trademark, do you need to register in each individual state as a corporation, or just the states that the businesses providing services and goods? That's a great question. So the trademarks are very different from your corporate registrations. A trademark is federal, right? It covers the entire country. So in the US, it covers all the states. In Canada, it covers all provinces. And you're not required to have a corporation to have a trademark at all, right? Your trademark can be registered in your personal name as an individual. So no matter what it is. And then your question, whether you need a corporation in every state, is not really a question I can answer, because that's more about whether the specific activity that you are engaged in requires you to have a corporation in each state. As far as I understand, no. You have to have one corporation, and then you can do business with all the other states from that incorporated entity in the one state. But again, I may not know things. I'm not a U.S. licensed attorney, so that's the question you would want to ask. Basically, so for example, let's say you're incorporated in Arizona, and then you want to start selling your products in Texas, right? So the question is, do you need also a Texas corporation to do that? I'd be shocked if you did, because all of the big names like Apple doesn't have 50 state corporations, and Nike doesn't have all those corporations in each state. So my assumption is the answer is probably no, but you may want to double check it. All right, what else we got? What if I use software to find high-value keywords, 7-figure monetization, before the trademark becomes generic, added to the dictionary? An example would be trademarking waist trainers before it became generic. So that's a great question. Love it. So you can get away with that. Certainly, you can get away with this for some time. And this is called the process of genericide. When something starts as a regular trademark, a regular brand, and then everyone starts using it as a generic term, and then there's a risk that someone will try to cancel your trademark on the basis that it has become generic. Some of my favorite examples are escalator, used to be a trademark. Linoleum used to be a trademark. Aspirin used to be a trademark. There's quite a bit of them. Kleenex is fighting like hell to preserve their brand, saying that Kleenex is not a generic term, that it's the name of a specific paper napkin. Who else? Well, Google, I mentioned already. It's fighting. Velcro is fighting. Xerox is fighting. So you have to take steps to not let your brand become generic. But sometimes, really, so what I see implied in your question is that you actually want it to become generic. You want it to become so widely used that you can monetize on that fact alone. And again, this could be a viable strategy. You have to be really at the very early stages of that wave, because trademark examiners are not stupid. What they typically do is they will do Google, they will do Wikipedia searches just to see if what you're trying to trademark is a term that is commonly used in the industry. And if they say yes, then you're going to be SOL about that. Like I said, if your trademark sneaks through, you get it registered and then it becomes generic. That's the beauty of a registered trademark. Until it's canceled, you are deemed to be the owner of a valid trademark. So until somebody can prove that it's generic, you can go and enforce that. And in many cases, people are not going to be willing to fight you over that in court or with the USPTO, and they will just, go with your demands until somebody says enough already. Let's kill that trademark, and that's what they're going to try doing. So let me have a quick drink. All right. What else we got? I hope you guys are finding this useful. I know I'm having lots of fun answering these questions, and keep them coming. Keep them coming. All right, so Carl Brody. Can we trademark or patent financial strategies like the Smith maneuver? Okay. I think it was like a week ago, maybe 10 days ago, I actually posted a video, what trademarks are not. And one of the first things that I said is that you cannot trademark your actual products and services. That you cannot trademark the idea behind your products and services. You cannot trademark what your product or service does. You can only trademark the identity by which the public recognizes your products and services and is able to tell your products and services apart from everyone else's. So if you got a name for your strategy, yes, by all means, you can trademark that, and it's often done. So it's not a financial strategy, but one of my favorite examples is in the SEO space, right? Search engine optimization. There was this guy, I think his name is Brian Dean. I think I'm not getting that wrong. But so there are a million SEO people out there. And he knew that if he wanted to stand for something and be recognized for something, he had to come up with a brand that would only be attached to him. And so he came up with the skyscraper technique, right? The skyscraper technique, there's really nothing groundbreakingly new about how he did things with the skyscraper technique, but he trademarked the name. And what that allowed him to do is to say that my company, Backlinko, is the only company that can help you build your search engine optimization, increase your rankings on Google by using our proprietary skyscraper technique. So everyone else can use it, but nobody can call it that way. So that's the one benefit. The other example that's coming close to protecting the actual strategy is if you can come up with a visualization for the strategy. So Robert Kiyosaki's cash flow quadrant, right? So he knew he couldn't trademark the idea or patent the idea of there are 4 types of income, right? The employee, the self-employed, business, and investor, right? He knew he couldn't protect it that way. So what he did is he drew a very simple quadrant, put the letters in there, and he trademarked the visual representation of that. And now he owns it, and by extension, he sort of owns the idea behind it. So that's really as close as you're going to get. With patenting, again, not a patent attorney. I understand how patents work to a certain degree. Everything that requires professional knowledge to be applied cannot be, or professional judgment cannot be patented. So that may be a problem for that. But again, the names, the visual representation of your financial strategy, that's something you can and probably should trademark if you want to stand out from the crowd of everyone else doing the same thing. Okay, so let's see. Is it worthwhile registering a state trademark to start with to get initial protection because it's much quicker? No. There are, the only reason you may consider a state trademark is if you're in the business of, basically in the cannabis business, because you cannot get a federal trademark on that. For everything else, I'd say a state trademark is pretty much worthless. It's very similar to you registering a company name or an LLC, or incorporating your company and hoping that registration will give you the rights to the name on the federal level, and usually it doesn't. Or at least in the very best case scenario, it does give you that protection if you're willing to then go and sue people over it, which is going to cost you 10, 100x of what the proper federal trademark would have cost you, and it's probably going to take you longer still. So there are no benefits to starting with a state trademark as opposed to a federal trademark. Let's move on. What we got? So if the business is only local in that state, okay, that may change things, because in the US you do need to show interstate use in interstate commerce, or at least that you're ready, willing, and able to sell your products and services to other states. So if all you do is always going to be limited to one state, maybe there is a benefit to a state trademark, but I think we'll live in a time when if you're building a business in 2022, you probably aren't building it with a view that it will only stay in one state, right? Even if it's a restaurant, right? One cafe. The last thing you want is for someone in the other state, because if you've got a state trademark, that's all you got, right? You protect it in that one state. So let's say you got California state trademark, and then someone in Nevada can lawfully start under that same name, and they may be 1,000 times worse than you are. They'll be getting all the bad reviews, and people will think that you are them. So by extension, you will be getting all the bad stuff from that, and there's hardly going to be any benefit. And also, that Nevada company can file for a federal trademark and prevent you from expanding out of California in the future. So, I mean, look, if you're building a business, the cost of getting a trademark is just a cost, right? You probably spend more money on other things. I don't know if you have a physical office, Your rent is probably a lot higher. Your monthly rent is probably a lot higher than what you'd pay for a trademark that's going to last for 10 years. And then you can renew it for a couple $100 every 10 years. You've got people working for you, you're probably paying them per month more than what you're going to pay to get your trademark done that's going to, again, last 10 years. There's a million things that we spend more than, like I said earlier in this live. On average, a client spends $3,200 with us, right? And if you go with one trademark in one country, you're looking at $2,500 plus the government fees. So there are a million things we spend more money on, and most of those things less important than a trademark. All right, let's keep going. So I got a question from Marlon. When you have a trademark, how to protect it? What markers have to be the same to file against the company? Say if the company has 3 names and 2 are the same as yours. So that's a great question, and I hope I understood what you asked correctly. But the cool thing about trademarks is not just that it's the only type of intellectual property that can, in theory, last forever. So as long as you keep renewing that trademark, it can last for hundreds of years. Like, for example, Coca-Cola has been renewing their same trademark they filed in 1892. The other cool thing about trademarks is that they don't protect you against just identical copying. They also protect you from similar brands that may be trying to take advantage of the popularity of your brand. So it's not as clear-cut as anyone would like it to be. Like, there's a lot of things that courts look at. There's a lot of criteria. They look at the overall similarity of the brands, the overall similarity of the products or services that they cover. And the question that they ask themselves is whether a regular consumer with a limited amount of brain power, when seeing the second brand, if they had a vague recollection of the first brand, when they see the second brand, would that person of limited intelligence, would they think that both products come from the same source? And if the court concludes that yes, it's likely that this average consumer with of limited intelligence, somewhat in a hurry, with an imperfect recollection of the first brand when faced with the second brand, if they would think that both products could come from the same source, that's called the likelihood of confusion, which is what you need to prove in a trademark infringement case, right? So whether it's 2 words, 3 words, again, depending on what those words are. If those words are generic, then it's nothing. So for example, if you have, ABC software solutions and someone else has LMNOP software solutions. So software solutions are the same, but neither software nor solutions, if you're both in the business of selling software, really identify your product. They don't distinguish your services apart from everyone else's. So just because you have the overlap in those terms doesn't make it a problem, right? It's whether ABC is too close to LMNOP, right? So, and also sometimes changing the order can switch things around. So it's very case by case. So I cannot answer this question in more detail, unfortunately, until I see the actual brands, and even then, it's just going to be an opinion. All right, what else we got? Question from Joe's. If you decide to change corporate legal name after the trademark has been filed or has been approved, will the packages cover the new change, and what process needs to be made? Great question. So, and before I answer this question, I'm also going to mention, this is probably one of the questions we get all the time. Do I need to do my LLC first, or do I need to do my trademark first, or do I need to incorporate first, right? And the answer is trademarks is a long process. It's much faster and easier to get your LLC or incorporation. And you can always do it later. So don't let the incorporation or registration over your LLC stand in the way of filing for your trademark, because someone can steal your trademark today, whether you own, whether you have your LLC or not. Much better to have that filed in even in your personal name, and then transfer it to your LLC, to your corporation, or whatever entity you're going to build to own that brand. So it's very easy. Our packages don't directly cover it, but we usually waive our fees because it's really simple. There's a government fee. If you're talking about US, there's I think $40 for the first trademark and $25 for any trademark after that. That's what you're going to pay to the USPTO for the transfer. And all you need is a one-page agreement between you and, or between the entity that is the applicant and the new entity. And that's going to say, we transfer our rights and goodwill in this trademark from us to this other company. We file it, and the Trademarks Office takes notice of that, and they put the new company as the new owner, right? So obviously, if you're not our client, taking care of just the transfer, we're not going to do it for free. If you're an existing client, especially if you told us about this prior, that, hey, I'm thinking of doing it in the future, we usually are going to tell you that, hey, no problem, let's file it under whatever name today. When you're ready, we're just going to switch it, and you're not going to pay anything extra for it. Right? You're going to pay the government fee for it, but we're not going to add anything on top of that. Okay, what else we got? Can I trademark a specific type of land or property if it's not a part of any dictionary and create a marketplace similar to the MLS or HOA? So I have no idea what HOA is. MLS, I think I have an idea. So you can't trademark the land because you don't sell land, but you can trademark the service around that, around what you're offering to the people, right? So again, trademarks, they don't, when you trademark something, you don't trademark the word, you don't trademark the thing. You trademark something that people can get from you, how they identify the product or a service that the public can get from you. So, whether it's a Big Mac, right, that's what you get. Or when you go to Mac Cafe or Starbucks, you get a service of a restaurant or a cafe, right? So land, no. Type of land, no. Probably not. But you can trademark something that you actually offer to the world, to the public, as a service. And that's really what MLS, as far as I understand, is. And again, don't know about the other one, but I hope this answer makes sense. All right, let's see if we got more questions. And Nick, thank you for taking care of the chat. I really appreciate that. So like I said, we're still trying to sort things through and create a better flow like all the professional YouTubers do, maybe one day. Again, I'm hoping that people are finding value in this type of videos and in this type of lives. I'm planning to do these every 2 weeks, so every second Thursday. same time, unless there's a good reason to do this more often, and we'll go from there. And there's one thing I was supposed to say in the beginning and I forgot, so I'm going to say it now. If you go to trademarkfactory.com, and what you can do, really, the way you get started with us, right? You go to our website, trademarkfactory.com, and you request a free call with one of our strategy advisors. And what they're going to do is they're going to talk to you. They're going to hear your story. They're going to understand why you want a trademark, and whether we're the right fit to help you with that. And they're going to walk you through the packages. They're going to walk you through your options, through the strategies. Really, there's a lot more than about them taking your credit card details that goes into that conversation, because we want to make sure that we're helping you use the proper strategy to best protect your brand, given your budget, given what your business does today, what it plans to do 2-3 years from now, where you need a trademark, whether you need a name, whether you need a logo, whether you need a tagline. All of those things you will actually get clarity on during that conversation. So if you do feel that during that call that you've gotten value from, or that you will be getting value from us, and you want to move forward with us, if you heard about this on the live, just mention it to your strategy advisor, and they'll give you $300 off. So we'll see if anyone was paying attention and actually takes advantage of this. But that's what I was supposed to be saying throughout this live. And of course, I forgot because I got so excited about your questions, guys. Really, really appreciate everyone asking questions. I love nothing more than, just go back to where I started from, because right now, as the founder and CEO, I do less and less work with specific clients. It's more about running the firm and making sure that everything's running smoothly. All the clients are taken care of. All the other things are in the company are taken care of. So when I get an opportunity just to do a blitz like this, it's a lot of fun for me. So okay, let's see if we got more questions. All right, so we got a problem. We got a question. Could there be a problem if your corporate name is just a word of difference from another corporation in Canada, although neither entities are on the same type of market? So short answer is no, unless it's such a famous company that it's got a trademark that's called a famous trademark that transcends goods and services. Failing that, first of all, a trademark in one country usually means nothing in the other country. So that's why you have to do trademarks on a per country basis. So unless you can prove that somehow there's a huge spillover effect from one country to the other, let's say your Canadian trademark is powerless in the US and the other way around. Also, trademarks are done on a per goods and services basis. So the same brand can be owned by multiple companies in the same country, as long as what they do has nothing to do with one another. Two examples I can give you are Delta. So we got Delta Airlines and we got Delta Faucets. And because nobody in their right mind will ever think, that they're getting airline tickets from a company that sells faucets or shower heads, right? That's why they can coexist. Or similarly, nobody is buying their shower heads thinking that they're actually buying them from the company they used to fly to their vacation in Hawaii, right? So because the areas of their products and services are so different, they can coexist. Another example is Blue Shield. So we got a registration for medical insurance, and we got a registration for the same name in a completely different company for welding services. So again, nobody in their right mind would think that they're ordering welding services from a company that they used that has such a great reputation with medical insurance, or the other way around. So if there's no likelihood of confusion, that goes back to that same question that I answered a while ago today. It goes back to the likelihood of confusion, whether a regular consumer, somewhat in a hurry, would think that the two products come from the same source, right? And if the answer to that is yes, then you got a problem. And if that consumer would say, no, these two things have nothing to do with one another, why do you ask me this? Then you don't have a problem. So I hope that answers the question. All right, so what we got? All right. So let's see if there are more questions. Okay, it doesn't look that way. Is there anything else you want me to cover before we call it a day? Nick, if you think that, and again, thank you for manning the chat. Nick is our COO and helps us with a million different things. Running this chat is one of those, apparently. So if Nick, you think I forgot to mention something, let me know, and I'll take care of that. All right, so I see a question from Marlon. So basically a slight few more details compared to the question I already answered. So flying high cannabis, sky high cannabis. So cannabis by itself, and in Canada. So first of all, let me say, because I said that you cannot trademark cannabis related brands on a federal register in the US, you can register them in Canada. So cannabis, that's that part about software solutions that nobody's going to look at. High, that's a good question. Flying high or sky high. You could make an argument both ways, right? And that's really what the trademark litigation often boils down to, right? You make an argument, they make an argument. You're going to say that sky high is too close because it creates that same image in the brain of a consumer. They would think that it's the same thing, and they would say, well, high is descriptive for cannabis because that's what cannabis is supposed to make you, so they would say the first name is sky and your first word is flying. So it could turn either way. Unfortunately, I wish I could give you a more specific answer. There just isn't one. I personally think, if I were to black and white it, right, and it's never black and white, but if I were to black and white it, I'd probably say maybe 55% towards it is confusingly similar versus 45 that it isn't. Another factor that they would look at is how many other trademarks there are that mention high for cannabis, right? If there's many of them, so there's flying high, there's sky high, there's super high, there is something else high, and they all trademarked, then it would make it harder to make a case that you should own the monopoly over high by itself without the flying. And if you're the only one that has high in your trademark, then again your trademark is stronger. Which is why it's very important how you pick your name, and also how you defend it, making sure that nobody else's trademark goes through and you oppose the other ones when they come in. All right, what we got? Okay, what about instead of trademarking the land or property type, you trademark the name of the type of land? It's not recognized. I think I covered this. Okay, maybe I'm just seeing the old ones because I did answer that question. I did answer that question that you can't trademark the land itself. You can trademark the services around that. So Nick, I am just waiting for your signal. What do we do? Do we call it done, or do you want me to talk about something else? See, I'm just waiting for Nick to message me on Telegram. That's our tech today. So, all right. Then we'll call it a day. You can play it simple, and I'm not gonna reveal what this simple thing is all about because we're going to be doing something very special about an announcement around this. But thanks everyone for joining in today, for your amazing questions, and we're planning to do another one of these lives not next week, 2 weeks from now, also Thursday. We'll post all, we'll be posting about this, and I hope you found some value in this call, and I'll see you next time. Signing off.